participants here for this webinar on Biological Diversity Act, one of the most important topic of interest for people working on biological resources. And as part of my opening talk, I was supposed to give a brief overview of the scenario, of the legal scenario of the biological diversity in India, regulations as such. And starting with it, I would just like to go ahead with the background, where how it all started. It started with the CBD, the Convention on Biodiversity, which itself came much further back. If we trace back, it goes back to 1945 when the United Nations came into picture, and Stockholm Convention in 1972, where the United Nations Conference on the Human Environment and UNEP was established. And that was the route for where our CBD, our own very CBD, comes into picture. And currently, this Convention on Biological Diversity has 196 members. All UN member states except USA are part of it. And the main idea of having the CBD in place were threefold: having conservation of biological diversity, taking care of sustainable use of its components, and fair and equitable sharing of benefits arising out of this. So with that international scenario in place, how it started in its background, we come to the Indian context, where the Act, the Biological Diversity Act 2002 was established. And when this was established, the definition of biological diversity becomes important. Now, biological diversity is defined very, very broadly in the Act, which means the variability among living organisms from all sources and the ecological complexes of which they are part, and includes diversity within species or between species and of ecosystems. So naturally, the regulation of biological diversity would be very difficult. So the regulation is focused on biological resources. And what are biological resources as per the law? They are plants, animals, microorganisms, their parts, genetic material, and bioproducts, which are having actual or potential use or value. Now, the value-added products are excluded. I will not go into the definition because it completely take 10 minutes going into value-added products itself. And the idea is that whenever there is biological resource being used, it has to be through prior permission. And this prior permission comes from the fact that the sovereignty of the state is established over all biological resources of that state. So whenever a biological resource is to be accessed, the users and providers, they reach an agreement that yes, we will be accessing it, and in return, we will be sharing some benefits. And the access and benefit sharing rules are based on Article 15 of CBD, where the governments create systems that facilitate access to genetic resources for environmentally sound purposes. They ensure that the benefits resulting from their use are shared fairly and equitably between users and providers. And the users seek access to genetic resources for scientific research, development of commercial products, or for whatever use they want to do. And the providers of these resources, that in exchange they would be getting benefits, which would be a share of whatever benefit the person who's accessing is doing. Now, there are three important terms I'd like to highlight here: PIC and MAT, besides ABS. PIC is prior informed consent. Now, the provider country has to give prior consent. That's the base of ABS regulation. And the agreement is to be based on mutually agreed terms, MAT. So whoever is working on biological resources and going ahead with getting permissions, do remember that it is prior permission, and any agreement which is given to you, you don't need to sign it, you can negotiate it. So these are the two important points I wanted to highlight. As far as Indian law is concerned, the law is in place, the Act is in place, the rules are in force. The guidelines are available both for access and benefit sharing, as well as several notifications related to exemptions. and the administrative infrastructure is in place, because the National Biodiversity Authority, with its head office based in Chennai, has been established, with state biodiversity boards in almost all the states now are currently functioning, and that goes up to the level of the BMCs and the maintenance of the People's Biodiversity Registers, the PBRs, also come into picture when there is a correlation between how the permission should be granted from wherever you are accessing. Literally, the source, we need to find out that there is no harm to the environment, there is sustainable use, and only then the permission is being granted. Now, as I said, that there are three aspects which are covered: conservation, use, and benefit sharing. These are in various aspects related to commercialization, research, and most importantly, intellectual property rights coming out of biological resources. Now, one intellectual property right, that is the plant variety right, is completely exempted out of the Biological Diversity Act, and rest all intellectual property rights, whenever they use any genetic resources, they require permissions under this act through the NBA or the SBB, as the case may be. And the biodiversity management committees are the one who are actually making all the decisions when it comes to the endangered species and rare species which are being collected from those areas. Now, I would also like to go into another point of the distinction between an Indian and a non-Indian entity, because the permission requirements for both the entities are a little bit different. Even for research, a non-Indian entity is required to approach the NBA before they start their work. But in case of only research, Indian and solely Indian entities can do the research on their own and then approach the Biodiversity Authority. So when I say research work, it could be as simple as coming up with a decoction or coming up with a new recipe. As long as you are doing it in your kitchen, it's fine. But as soon as you put it in the market, you are supposed to approach the Biodiversity Authority for any such work. Besides that, the transfer of your research results, which the transfer could also be outside the country, and collaborative researchers between the government institutes and those international institutions. They have different things, and Dr. Tripathi will be touching upon it, so I will not go deeper into that right now. And also I have 1 more minute left, I know. So basically, there's several committees before the National Biodiversity Authority comes into picture on itself. There are expert committees on agrobiodiversity, on normally traded commodities, on access and benefit sharing, on medicinal plants, and besides how the implementation of the Nagoya Protocol happens for the access and benefit sharing. So a particular percentage amount, how it is decided that this will be going to be the benefit. All of them are not one-person job. There's a lot of work going on before each permission is granted. So coming back to the most important point again and again, you have to think in advance, because prior permissions are required, no matter which industry you are in, whether it is drugs, enzymes, foods, flavors, fragrances, cosmetics, emulsifiers, all your resins, colors, extracts, even genetic work related to crop improvement and livestock genetic intervention. The only exemptions being conventional breeding. So you have to be careful that you plan in advance. And if you do not, the penalties are really high. It is imprisonment up to 5 years. And the fine can go up to 10 lakh of rupees with compounding. And in case of you do it again and again, then these offences are cognizable and non-bailable offences. So this is serious, and this act cannot be taken lightly. There are several cases, plants, including animals, pharmacy, the Divya pharmacy case, the Jitropha misappropriation case, the embryos of their breed cattle from Gujarat to Brazil, the export of Malabar breed goats from Kerala to Australia, the notices issued by the State Biodiversity Board to different companies which are existing for manufacturing purposes in those particular states are all now coming into picture. And thus, it is very important that the importance of this act is realized and compliance is made. So with